The Director General of the Department of Home Affairs. Let me not start on a wrong footing. My colleague, the Deputy Minister of Home Affairs, Re Njabule Nzuza, the Director General of the Department of Home Affairs, Mr. Tommy Makode, the Deputy Commissioner for Operations of the Border Management Authority, Major General Chilembe, members of the Refugee Appeal Authority who might be present, and the Standing Committee on Refugee Affairs, senior management of the Department of Home Affairs, media houses at large, and thank you very much for honoring us, and all the guests present and people listening on the live stream. Exactly 4 years ago, the Department of Home Affairs embarked on a painstaking exercise of drafting the white paper on citizenship, immigration, and refugee protection towards a complete overhaul of the migration system in South Africa, and will from now henceforth refer to this whole heading as the white paper. The process resulted in the Cabinet approving the white paper on Wednesday, the 1st of November 2023, for public comments. The white paper has been published in the Government Gazette number 49661. I repeat, 49661 on the 10th of November 2023. We will attach a copy of the Gazette to this statement. Conflicts, armed violence, disasters, pandemics, seeking better business and work opportunities, and other factors force people to leave their countries of origin to other countries. There have been consistent, loud voices calling for effective policy measures and legislative interventions dealing with migration in South Africa. These voices grow louder as violent clashes between foreign nationals and citizens rear their ugly heads. Many groups for and many groups against migration are gaining momentum. South Africa has different pieces of legislation dealing with citizenship, immigration, and refugee protection. These are the Citizenship Act, which is Act number 88 of 1995, the Immigration Act, which is Act number 12 of 2002, and the Refugee Act, which is Act number 130 of 1998, all of which have been amended. In fact, the South African Citizenship Act is a relic of the colonial era and a replica of the 1949 Citizenship Act under the Union of South Africa. Now, in practice, these pieces of legislation are not in harmony with each other. Piecemeal amendments were made without any policy framework whatsoever. If I'm not mistaken, the Immigration Act has been amended 5 times already since it came into existence in 2004. And all those amendments were just piecemeal. Let me come to the issue of refugee protection. The United Nations adopted the 1951 United Nations Refugee Convention. And in 1967, the United Nations adopted protocol relating to the status of refugee. Meanwhile, the Organization of African Unity, today known as the AU, endorsed its own 1969 OAU Convention governing the specific aspects of refugees' problems in Africa in order to deal with peculiar circumstances of migration and refugee in Africa. This was done in the spirit of Pan-Africanism. The 1961 Organization of African Unity Convention prohibits refusal of entry, expulsion or extradition of asylum seekers and refugees, and also provide for certain exclusions on certain grounds. In fact, the refugee laws in most of the African Union countries, based on the 1969 OAU Convention, are more stringent than the Refugee Act in South Africa. Furthermore, the principle of Pan-Africanism does not promote illegal entry in the countries that are signatories to the 1969 OAU Convention. Asylum during the apartheid era. Asylum seekers and refugees were not recognized in South Africa until 1993. During the apartheid era, South Africa did not accede to any of the international or regional conventions relating to the status of refugees and asylum seekers. South Africa administered its own refugee policy on an ad hoc basis, granting refugee status mostly to white nationals from Zimbabwe, Portugal, and Mozambique. The Aliens Control Act governed immigration during the apartheid era. The preferences of whites over non-whites, so-called non-whites or blacks, became the focus of the immigration policy. The Refugee Act was passed in 1998 in line with the 1951 Convention, the 1967 Protocol, and the 1969 OAU Convention. In other words, in line with all the other international conventions that exist in this field. Now, the Refugee Act in South Africa prohibits refusal of entry, expulsion of, or extradition of asylum seekers and refugees. Let me come to the accession of these international agreements. In 1996, 2 years after the first democratic elections, South Africa acceded to the various international conventions, the three that I've mentioned. But this was done without the government having developed a clear policy on migration, including refugee protection. Now, the government did not make reservations and exceptions permitted in terms of international law. All these international conventions I've mentioned, they provide for countries to take exceptions and reservations on areas that will be difficult for their countries to carry. But unfortunately, we did not do so. Both the 1951 Convention and the 1967 Protocols provide for these reservations. In terms of Article 42 of the 1951 Convention, which we have attached to the white paper, the convention has got 46 articles. And in terms of Article 42, any state may make reservations to articles of the convention other than Article 1, Article 3, Article 4, Article 16.1, Article 33, and Article 36 to 46. Article 1 is about definition. Article 2 is about discrimination. Article 4 is about religion. Article 33 is about, Article 16.1 is about access to the courts. And Article 33 is about refoulement, a French term meaning retaining a person from the country where they might have run away from persecution. And Article 36 to 46 inclusive are about administrative issues. Now, the United Nations was saying, on these mentioned articles, you can't make reservations. But on any of the 46 articles except this, a country can put reservations and exceptions and say, on this one, we are unable to. Article 7 of the 1967 Protocol provides for any state to make reservations in respect of Articles 4 and 1, other than the articles that I've read before, 1, 3, 4, 16, and 33. Many countries around the world make these reservations as provided for by both the Convention and the Protocol. South Africa, unfortunately, did not make any of these reservations as other countries did. And we believe and we emphasize it was a serious mistake on the part of government. It is not surprising that South African courts developed jurisprudence regarding asylum and refugees in the absence of these reservations and exemptions. And the jurisprudence that has been developed is always unfavorable to the interest of the state. Now, what is our policy framework recommendations when the state of affairs is like this? The white paper proposes that the government of the Republic of South Africa must review and or withdraw from the 1951 Convention and the 1967 Protocol with a view to accede to them with reservations like other countries. And I don't want this fact to be misconstrued because people might get excited about it, and I want to emphasize there is absolutely nothing wrong that the United Nations have done. The United Nations did nothing wrong. They did everything according to the book. But there is everything wrong that we as South Africa has done. And so this white paper proposal is not against the United Nations, but it's ourselves who must reset. We are saying, as a country, we need to press a reset button. It is us, not the United Nations, who in 1996, when we interacted with the United Nations, committed these errors. And we are here today to accede to them and say we have started the process, or we are calling forth a process of correcting them. And we are putting this to the public out there. The refugee protection and immigration legislation must provide for reservations and exceptions contained in all these conventions. Particularly that South Africa, obviously everybody knows, does not necessarily have the resources to grant all the socio-economic rights that are envisaged in the convention. And even the richest countries in the world have posted their reservations and exceptions. Let's come to the issue of citizenship. The genesis of the 1949 Citizenship Act and the present Citizenship Act, which we passed in 1995, 1 year after democracy. The current citizenship legislation, which we are using now to grant citizenship in South Africa, had its roots in the 1949 Citizenship Act and other relevant successive laws governing citizenship. The 1949 Citizenship Act and other relevant laws were not only discriminatory on the basis of race and sex, but the natives, meaning black people, were totally excluded from the South African citizenship regime. It is quite unfortunate that when you read today's Citizenship Act, you see a lot of similarities with what happened in 1949. In fact, I may say it looks like a cut and paste with changes here and there. For instance, in the 1949 Citizenship Act, they never refer to any mother. They always say father. Your citizenship is based on your father, as if mothers do not exist. What we did, unfortunately, in 1995 was just to replace father by parent, and thought we were making changes. But this, I believe, were really cosmetic changes. The South African Citizenship Act provides for three main forms of citizenship, namely citizenship by birth, citizenship by descent, and citizenship by naturalization. Now let me come to policy framework which we are proposing under citizenship. The white paper makes radical proposals regarding citizenship. Section 4.3 of the Citizenship Act requires to be reviewed together with other sections, including those related to citizenship by naturalization, during the new legislative process, when we start pressing the reset button. In the United States of America, Canada, Switzerland, and Britain, which are very highly developed countries with resources that far exceed the resources in our country, have developed strict immigration, citizenship, and refugee laws in order to protect the rights of their citizens. The Citizenship Act and Birth and Death Registration Act must be repealed in their entirety and be included in a single legislation dealing with citizenship, immigration, and refugee protection. This will remove contradictions and loopholes in the path towards citizenship, as is now the case with the three pieces of legislation. One just need to refer to what happens recently in the widely publicized case of Afghan nationals who wanted to enter South Africa through Beit Bridge. The lawyers for the state fought a gallant battle using the Immigration Act. But all the court has to do was to point to the Refugee Act and pointed to a section that completely contradicted what the Immigration Act is saying. And we can't go on like this. So the criteria for granting any form of citizenship must be strictly in accordance with the law. A proper register should be kept for all persons granted citizenship by naturalization by the minister. The register must be tabled every year in Parliament by the minister. Under no conditions would we like to repeat the embarrassment of what happened with the Guptas. And I'm sure you are well versed with the story. I don't have to repeat it. How they got naturalized in South Africa. Let me come to immigration. Before the Immigration Act 13 of 2002 was enacted, the applicable legislation was the Aliens Control Act and the Aliens Control Amendment Act. Now, South Africa today is a great place to live in, and many people in the world aspire to live, work, or be citizens of South Africa, even though some South Africans don't believe this. In the results, many foreign nationals come to South Africa and stay in the country illegally. No one can account for all the undocumented migrants. The Department of Home Affairs has no idea as to how many illegal migrants are in South Africa. And we are asked this question time and again, and we have responded many times that we did not know because there is no mechanism of knowing. There are those people who believe that South Africa know. It doesn't. It doesn't. And I've checked this many times with the Statistician General, especially after the recent statistics has been released. It doesn't. The Statistician General said, I can even quote him, that they don't investigate or assess people's nationalities when they do stats. Not even, they ask you, and they put the answer you give them. If they ask you where you come from, if you say South African, they'll write South African. There's no way that they'll do anything else. If they ask you the status of your pregnancy and you tell them you are not pregnant when you are not, they're not doctors. They are not going to put you on the table and examine you. They will check you there that you are indeed pregnant. That's how they do it. They just count. So nobody must tell me that they will know the number of illegal immigrants, because nobody can ever tell South Africa or even Home Affairs that yes, I'm illegal. No human being behaves like that. I don't know why we expect them to behave differently. However, immigration services deport between 15,000 and 20,000 illegal foreigners every year at a huge cost. And this number is on the increase. The establishment of the Border Management Authority, represented here today by Mayor General Chilembe, should significantly reduce the risk of foreign nationals entering the country illegally. And again, like I did with United Nations, I want to emphasize this. People like to misconstrue facts that we established the BMA to stop people from coming into South Africa. We're not doing anything of that sort. All we are doing is people must come into the country legally. And the president said so when he was answering questions in Parliament a few weeks back. Our problem here is illegality, not people coming to the country. I want to emphasize that. The Immigration Act introduced fundamental changes, albeit controversial, and a host of visas, such as temporary visa, study visa, business visa, critical skills visa, corporate visa, spousal visa, retired visa, relatives visa, intra-company visa, permanent residence permit or visa. I can go on and on. There are 17 in all. And I'm not sure whether I know of any country anywhere in the world that has got so many different types of visas, which are obviously an administrative nightmare for officials in the department. Now, what is our policy framework proposal on immigration? The white paper proposes that border control must be coupled with immigration, meaning the whole Immigration Act and the BMA Act will have to be integrated. The United Kingdom Parliament introduced in November 2021 the Nationality and Border Bill, as we know. The Border Management Authority Act must be reviewed so that we align it with the Immigration Citizenship Act as new policy framework, because they were all passed differently at different times without referral to each other. The policy framework must provide for the establishment of the advisory board, which comprise of representatives from the Department of Trade, Industry and Competition, the Department of Labor and Employment, Department of Tourism, the South African Police Service, the South African Revenue Services, SARS, Department of Education, both basic and higher education, Department of International Relations and Cooperation, Department of Military, Department of Defense and Military Veterans, and the Director General of the Department of Home Affairs. The board must comprise representatives of organized labor, including 4 individuals on the grounds of expertise in administration, regulatory matters, or immigration law, control, adjudication, and enforcement, appointed by the minister. I have published the critical skill list in August 2022. The critical skills list is necessary to attract foreign skills required for the development of South Africa. And there have been lots of noise and controversies about this issue, about critical skills and people who are supposed to be stopping for critical skills. It's not a subject for today, but I'm inviting you. Tomorrow evening, I'll be appearing on Dr. J.J. Stabani's show power to truth, to deal with this matter and give facts and figures, because facts and figures don't lie. Not hot ash, as I've heard in the past few days. The critical skills list was compiled with consultation of relevant stakeholders, including NETLEC, in which the state, labor, private sector, and society, and community rather, sits and look into these issues. Policy and legislative interventions are required to tighten the procedures and strengthening the monitoring capacity by introducing IT systems capable of flagging fraudulent activities in the issuing of visas, ID documents, marriage certificates, and passports. This includes giving wide statutory powers to existing anti-corruption unit within the Department of Home Affairs. So the new policy must provide for the members of the anti-corruption unit and that they should be seconded from the South African Police Service. The rationale being that members of SAPS enjoy wide statutory powers, including search and arrest without a warrant. New legislation must be introduced to strengthen the powers of immigration officers and inspectorate and make for them for continuing training, which must be compulsory. The majority of members of the inspectorate must have legal qualifications and policing experience. I know this will be a tall order, but that's how many countries around the world deal with the issue. They don't just take anybody to deal with. They take very highly trained people. So the inspectorate that we must have, they must have legal qualifications and policing experience. The recent publication of the National Labour Migration Policy, introducing quotas for employment of foreign nationals, will go a long way in diffusing simmering tensions between South African citizens and foreign nationals. Perhaps I need to explain what this is all about. A few years ago, maybe 2 or 3 years ago, Parliament raised this issue sharply when the President was answering questions in Parliament. The issue of jobs for nationals and the issue of jobs for those who come from other countries, because it's also an area of controversy. The President responded that he will choose an interministerial committee on migration to deal with this matter. I was appointed, or rather the Minister of Labour and Employment was appointed with me to co-chair this committee. And I can inform you today that the committee has put together lots of experts, even internationally, to develop a national labour migration policy, which, as I'm saying, has gone through all the stages, is about to go to Cabinet, who, if adopted, must release it to Parliament so that they pass legislation. That's where we are now. When the Immigration Act was enacted, provision was made for the establishment of the immigration courts. However, the Immigration Act was amended in 2004 to remove the establishment of the immigration courts. Now, the new policy framework and legislative intervention is required to establish the Immigration Division, whose members are duly qualified to deal with granting of various visas. The current system is unworkable, and staff members are completely overworked. Appeals or reviews are dealt with by the DG and the Minister. Given the responsibility that the two have, it is impossible for them to deal with all the appeals and reviews. And I can tell you, everybody who has been rejected, whether legitimately or not, they appeal and keep on appealing. Given the current challenges, there's merit in establishing an independent body to deal with appeals and reviews, such as Immigration and Refugee Board, Immigration Division, Refugee Protection Division, and Immigration Appeal Division. We learn from countries like Canada, where Immigration and Refugee Protection Act of 2001 in Canada makes provision for the Immigration and Refugee Board, consisting of Refugee Protection Division, Refugee Appeal Division, Immigration Division, and Immigration Appeal Division, or Special Immigration Appeals Commission, as they are doing in the United Kingdom. Now, if you come to South Africa, the Canadian equivalent of this board is the Refugee Status Determination Officers, or people who are legally referred to as the RSDOs. Now, they are an equivalent of what is called Refugee Protection Division, or RPD in Canada. Now, this RPD is a statutory body charged with the responsibility of taking decisions on asylum applications. In order to avoid backlogs, its members are appointed on a full-time basis in terms of the Canadian Public Service. In other words, the Refugee Protection Division in Canada performs functions that are assigned to the RSDOs in South Africa in terms of the Refugee Act. Now, the main difference is that this RBT, or Refugee Protection Division in Canada, conducts proper hearings with asylum seekers being afforded the right to legal representation. This will obviate the long-winded and tedious appeal process under the current legislative regime. Ladies and gentlemen, I want to tell you, the appeal process in South Africa, we dubbed it the blue sky. Everybody knows that the blue sky has got no end, doesn't end. And unfortunately, the appeal process in South Africa is like that. You appeal and appeal and appeal and appeal forever and ever and ever. And if one day you decide that you are tired of that, you go and start afresh in an open court. That's why, ladies and gentlemen, that's what rather happened in the Cape Town. The people who illegally occupied the Central Methodist Church in Cape Town under the tutelage of refugee or asylum seekers. There are three ringleaders: a lady called Aline Pakur, a gentleman called Papi Sukami, and the biggest ringleader of them called Jean Bie Palus. They spent 13 years on this unending appeal process. 13 full years, claiming to be asylum seekers and refugees. And after 13 years, they eventually were presented in an open court to a magistrate who instructed that they must all be deported. And on being deported, when Papi Sakumi arrived in the DRC, he tweeted internationally that he has formed a political party, and nothing happened to him, regardless of the fact that he spent 13 years claiming to be running away from DRC because the people who are in charge there are persecuting him. Now, this just shows some of the problems that we were faced with. And we have to deport them with 40 others who also spent an equal amount of time in South Africa claiming this asylum status, but making use of an unending appeal process. So in this new proposal, a party that is aggrieved by the decision of the, in the situation in Canada, which we want to make our proposal, the people who are aggrieved by the Refugee Protection Division, when it seeks to decide on their fate, must appeal to the Refugee Appeals Division, with majority of members being appointed on a full-time basis, and 10% of whom must be members of the bar or attorneys for at least a period of 5 years. That means you must have been in the bar, meaning a senior counsel or an attorney, for a minimum of 5 years before you can sit and hear this type of things. Furthermore, the Canadian legislation clearly makes a distinction between economic migrants and refugees. We want to adopt the same position here in South Africa, and the white paper is exactly adopting that. There must be a difference between a person who's coming to the country for economic reasons and those who come for as refugees, because the two things are conflated everywhere, even in government, in the media, and in public. People do not understand or want to realize that there is a difference between an economic migrant and a refugee. They are not one and the same thing, and they don't represent one and the same thing. The United Kingdom, UK, adjudicators who are equivalent to these refugees determination officers in South Africa must be members of the bar or attorney for a period of 7 years. In Canada is 5 years. In the UK is at least 7 years. This strict qualification requirement in these two countries are because, ladies and gentlemen, asylum matters are by their nature complex because they involve international refugee law. And believe you me, international refugee law is never easy. Sometimes even for people who are legally trained. That's why the countries put the bar high and say you must have been 5 years in that job or 7 years. We have to do something like that. I've got nothing against the RSDOs, but if you look at the act, many of them are extremely junior. Getting a junior person to deal with complex international law, then people appealing, bringing big guns in the bar in the form of senior counsels to ravage everything that has been done. It's an experience that we can't keep on keeping. We have got to change from that. Policy framework proposals on refugee protection. The new policy framework and legislative measures must include the establishment of structures such as is happening in Canada. The decision-making powers will be quick and virtual hearings can be introduced at the ports of entry, as we have seen in countries like the Netherlands. So consideration will be given and provided for in the new integrated legislation that we are envisaging to appoint either serving judges or retired judges or senior counsel as chairpersons of the appeal bodies. The instances of unlawful entry into the Republic, an additional requirement must be, in instances of unlawful entry into the Republic, an additional requirement must be introduced that they must show a good cause for their unlawful entry or presence. They must show good cause. They must say, I've entered the country illegally. These are the reasons, and the reasons must provide for good cause and be understandable. The minister should be empowered to declare an asylum claim made by an asylum seeker who has a connection to a first safe country invalid. In other words, the first safe country principle must be strictly applied. This will include a person who may apply to be recognized as a refugee in that state. There are some members of parliament who have asked us about this. We know very well that the international conventions do not necessarily provide for that, but many countries around the world provide for this in their own legislation, seen when they notice that people cross many other countries to come to theirs when they claim to be persecuted. And it's not very clear, and they never explain why the first country they entered, which is not safe, they never applied for that asylum there. And these questions were raised with the Afghan nationals who went to Pakistan, went to Qatar, went to Zimbabwe, but eventually when they arrived in South Africa, that's the only country where they applied for asylum. Why not in the other preceding countries? And of course, I remember their lawyer was asked a question in that regard. He said, no, we have studied the laws of all these countries and found that the easiest country to enter is South Africa because of its laws. That's why today I'm saying we're here to press the reset button, because we don't want to be characterized like by that anymore. This policy framework will discourage asylum seekers who deliberately fail to apply for asylum at the first safe country, which is a signatory to the 1951 Convention, the 1967 Protocol, and the 1969 OAU Convention. Furthermore, it will deter economic migrants who enter South Africa disguising as asylum seekers rather than being clear that economic migrants. Perhaps it's because there's no law in that effect. To that effect, that's why we are proposing that the white paper must show the differentiation between these economic migration refugees. In conclusion, I take this opportunity to thank all the concerned citizens and staff of the DAH who worked tirelessly in developing the policy frameworks contained in this white paper. An explanatory memorandum will accompany the distribution of the white paper to the public at large. I call upon all citizens and stakeholders to make comments to enrich the white paper. Public participation is a principle that underpins our Constitution. I thank you.
Thank you very much, Minister, for the comprehensive statement. We will now open the floor for questions from members of the media. Please identify yourself and the media house from which you come. In that order, 1, 2, okay, let's go.
Sorry?
Just use the mic.
Minister, you mentioned that we report about 15,000 to 20,000 illegal immigrants in the country per year. Can you give us a figure on how much do you spend to deport these people? And then you mentioned that the UN did nothing wrong in terms of the laws. And then you come back 2 decades later, you say, no, we were wrong for not bringing our delegations forth. So will this not cause any conflict with the US? Thank you.
Thank you.
Just building on the image that I just had in terms of how long it has taken the government of South Africa to really reflect on its migration law. How much consideration or engagement were held with civil society who have been taking government, especially the Home Affairs Department, to court over national relations to migration, whether the larger community or other ways. So how much consultation has been done with other relevant stakeholders outside Parliament or outside government of the Home House? But also in terms of the clear speech, this white paper can actually result into the actual laws of government. We know that since about 5 years or so, what can be happening, what can be done between now and the duration of the passing of this right paper into the actual law. In the meantime, does that leave government still vulnerable to legal challenges in the meantime, or this also the process is still ongoing?
Okay. Minister, before you respond, Tagalani, can we check if we have questions online on the WhatsApp group?
We don't have questions online. Thank you.
Okay, sure, thanks. Minister?
Yes, the first question from Herman from Sowetan is how much we're spending on deportation. Unfortunately, I don't have a figure here, but I can tell you it's not cheap because in terms of the law, we have to hire transport and there are service providers who are doing that. It's only recently with the establishment of the Border Management Authority that they have ordered their own buses to try and do this job. But up to now, when we deport people from Lindela Repatriation Center, there are people who are service providers who have been accrued, I mean, the department has accrued them through the normal processes of accruing services from outside providers. And I want to add, if you must deport a person from a place like the DRC, you've got to hire a chartered flight for that. So it's not easy. And that's exactly what we have done for this 40. That's what we have done for Aline Pakuru, Papi Sukami, and of course Jean-Pierre Palus. We could not deport because he was in jail at that time for causing commotion at the Central Methodist Church for assault and all that. He was in jail, and we could not deport him, but we still want to do so. Unfortunately, when the court released him, they never told Home Affairs, and he has gone underground, but we are still searching for him. Now, your next question, Herman, is that the UN did nothing wrong, but we turn around and say we want to review, won't it cause conflict with them? No, the UN did nothing wrong. They passed 46 articles in 1951 in the convention. And Article 42 clearly states that countries are allowed to make reservations and pass and do exemptions. They are allowed, it's part of the article. South Africa didn't do so in 1996. Perhaps because we did not understand these things or we lacked experience, because by 1951, we are not members of all these conventions. So we are just doing what is provided for by the United Nations. And I want to give you a very good example why I'm saying so. Article 33, which they say you can't refoul. Refoul is a French word, refoulement. In fact, if I were to be French, I would say refouler. But because I'm African here in an English-speaking country, we keep on saying refoulement. It's a centerpiece of the convention that you can't send back a person to a country where they might be persecuted and even sometimes executed and all that. But even the United Nations then knew very well that there will have to be exceptions. You can't say everybody can be refouled. What about thugs? We do have international thugs and syndicates who run to South Africa. The most well-known recent one being Fulgence Kayishema from Rwanda. I'm sure you heard how the United Nations celebrated when he was arrested here in South Africa. You can't pass a law that say he can't be refouled. So for that reason, the United Nations provided for these exemptions, but we never took them. So Article 33 of the United Nations Convention, which says you can't refoul, they say so in subsection 1 of that article. But in subsection 2, they clearly define the exceptions under which you can refoul. They clearly state that in the second part of the article, which is subsection 2. But what happened in South Africa? When we domesticated that United Nations Convention into the Refugee Act in 1998, we domesticated the first part, 33.1, which you say you can't refoul, and completely ignored the second part, which says there are exceptions under which you can refoul. So it's not United Nations, it's us. And we are resetting and trying to correct. And I don't understand why that causes conflict with the United Nations, because they provided for it. They said make use of these apparatus, and we never did. And we are in trouble today because we never did so. If you look at Section 2 of the Immigration Act, it's clear that it just took Article 33 of the United Nations. It just took it and put it into South African Parliament and ignored the second part, which allows you a leeway when you are faced with problem. What does Section 2 of the Refugee Act says in South Africa? Among others, it says no one may be refused entry into the Republic. Tell me any country that is acting like that, and tell me that the United Nations passed a convention with a belief that no one can be refused entry into any part of, in any country in the world. It doesn't happen that way. And in South Africa, we put it in the Act, and we say it was wrong. So all we are saying is, we're not fighting United Nations. We want to correct our mistake by saying, United Nations, bring back what we entered into with you because it was wrong. We'll enter it afresh and correct our mistakes. That's all we are saying. If that causes conflict, I don't know. I don't know. Why should there be conflict on that? The second question is, how long have South African government, how long have we been dealing with these issues? I think for a long time, like the Immigration Act was passed in 2002. It came into effect in 2004. But immediately in 2004, there was already an amendment. And it kept on being amended until, as I said, it's 5 times. Meaning what? Why so many amendments on one act within a short space of time? It's because South Africa was already experiencing problems. And instead of solving the problems, we're doing piecemeal knee-jerk and say, let's throw this in, let's throw that in, let's throw that in. And now we are saying, no. In fact, the amendments are such that even government officials themselves are now confused on how to apply them. And time and again, we look like fools because the amendments have been so many and varied that they no longer know where we are. Only a very well-qualified lawyer who understands interpretation of statutes will understand that. And we can't go on with that because many government officials are ordinary citizens. The issue of consultation, we are passing this white paper today for consultation with the public. We developed it after many, many arguments. You may remember that in January 2020, I think I was just 7 months in the Department of Home Affairs. We issued regulations to amendments which were passed in 2013. And there was a big uproar from civil society, legal bodies, and many others about those amendments. And I put together a group of legal experts who confirmed that the uproar is legit. These amendments that were made here were wrong. We were supposed to go to court to review those amendments, as is done. You are aware that in South African law, or I'm sure many other destinations, when you have passed a particular law and discover a mistake in it, you can't just cancel it. You have to go to the court to review it and cancel it. We were going to court for review, but we stopped because we said, no, this is another piecemeal. Let's overhaul the whole thing and start from the scratch and reset. That's why we are doing, and now we are consulting the public. As to the ruling party, they've been dealing with this matter for the past 18 months. I took it to the policy conference in June 2022. It was debated there. From there, it went on for 6 months. We took it to the national conference in December 2022, where it was finally adopted. And now we are giving it over to the public. How long will it take to pass the white paper? As I have said, the accompanying letter here is that we are giving members of the public up to the 19th of January to give their inputs, after which we will include the inputs, incorporate them, send it to cabinet, and the cabinet will look at the inputs, and if they adopt them, then it becomes a white paper. You are aware that a white paper is not necessarily an act. It is a policy. The act here from the white paper will be the repeal of the Citizenship Act, the repeal of the Refugee Act, the repeal of the Immigration Act, restarting them again and afresh as one law, as many countries are doing. And there's merit into that. A person who comes today as a refugee may tomorrow be a citizen. A person who comes as an immigrant, just visiting, may tomorrow be a citizen. And so why do you have different acts administered in different parts of the government when we are dealing with exactly one individual? It causes confusion. So the white paper would like to give a foundation upon which the acts will be repealed and started from the beginning. Thank you very much.
Thank you, Minister. Do we have further questions? Tagalani?
Thanks, Joe. 3 questions are coming from Carol Patton from News 24. And the first one is, what is the plan for ports of entry? Will people be obliged to report at the port of entry? And what happens if they do not? And the second question, when it comes to labor migration and so on, do you see a distinction between nationals from Southern African countries and the rest of the world in terms of right to work in South Africa? And the last one, in a nutshell, if the proposals in the white paper become law at some point, how will life be different for South Africans who at this point are out competed in some sectors like services and in running spaza shops? Thanks.
Thank you, Tagalani. This would be the last batch of questions, Minister.
Don't make it the last batch. Some people are still thinking. This is a very weighty matter. I don't want to leave here with unanswered questions. This is the beginning of the public participation we're talking about, so allow them to engage. Well, if they run out of questions, it's okay, but let it not be us who stops them, because some of them from the answers I've given would like to do follow-ups and all that, which must be allowed. The plan for the ports of entry, are people obliged to report at the ports? Yes. We are saying people must come legally. When you report at the port of entry, they fingerprint you, they may even photograph you, they take your details, and we know that we have entered the country. The people who ask us questions every time will stop asking us questions because we'll have the details of who is in or out. If you just jump the border illegally and come here, it's wrong. But it's not that we are saying those who are running away from their countries, they can't jump. But the law provides for that. Only that we want to correct the manner in which it states it. If you cross a border at the point that is not a port of entry, you must immediately report to the nearest refugee reception center. And there are 5 of them in the country. We've got one in Musina. We've got the biggest one here in Marabastad in Tshwane, called the Desmond Tutu Refugee Reception Center. We've got one in Gqeberha, and we've just opened a state-of-the-art building in Epping, in Cape Town, for that refugee reception center. It is really a state-of-the-art if you go and visit it. We've got one in Gqeberha, and we've got one in Tekwini. But many people cross the border illegally, and they don't report there. And I'm sure you are aware, despite the fact that South Africa is always under attack on refugee legislation, we are the only country, unless one can point to another, at least on the continent, where we don't put people in camps. We are not encamping people. They stay around us. And so it's easy to disappear into the population. Whereas in other countries, they throw you into a refugee camp, and they know that you are there, and you can't leave without permission. We don't do that in South Africa. Even though I know we don't earn kudos for that, we actually earn scorn for doing something like that, which we believe is so good and human. The labor migration policy, whether it will differentiate between SADC and other countries, I think it will be difficult to answer this question until the document is out. Because as I said, Minister Nqesi did get experts even internationally who will look at this. Remember, South Africa does have certain agreements with SADC on these issues. And so they will have to be incorporated in that document. And standing here, I'm not even actually able to state exactly what is there. Just wait until the document is out. because it will go to Parliament, which will do public hearings, by the way. There will be ample opportunity. The new law, how will it affect change? And an example of Spasa Shaw beer was given and all that. I think if you read the white paper and the statement I've made, you realize that there will be lots and lots of serious changes, including the manner in which we interact with refugees and asylum seekers, including the people who are going to interview them and find whether they are telling the truth or not. And maybe I need to explain for those who might not know what I mean by that. I told you of the 3 international conventions and the 3 pieces of legislation in the country. When you come, the conventions provide for under what conditions do you skip the border illegally and go to another country. Maybe it also answers the question from Carol Payton about what happens when people jump borders. The United Nations clearly outlines that in the 1951 convention. It says when there is war in your country, you can't do that. And if you are crossing into a country that is a signatory to a convention like we are, it ought to allow you in. It also says if there are natural disasters like floods, fires, volcanoes, earthquakes, you can cross the border anywhere without any papers, because that is provided for. But provided you go and announce your presence, the problem is to arrive in another country and never even mention that I'm here. The third thing is if you are persecuted, and I think that may be the main one, persecution. And 4 areas of persecution are recognized under the United Nations conventions. The first one is if you are persecuted for political activities and for your political beliefs and activities. Secondly, if you are persecuted for your traditional beliefs and activities, which the rulers of that country may say they don't want. Thirdly, if you are persecuted for your religious beliefs and teaching and activities, which the rulers in that country say we don't like what you are teaching, we don't like the religion you are propagating, it's bad for the country, they may persecute you. And lastly, if you are persecuted for sexual orientation, you know this is a subject of intense discussion around the continent now. The issue of sexual orientation. Now, the RSDO, or Refugee Status Determination Officer, in these 5 reception centers, their job is to determine the truthfulness of that. Is there war in your country? Is there a natural disaster? Are you really being persecuted? And there will be 2 outcomes. There will be 2 outcomes, or maybe, let me say 3. Because the third one is if you are granted. But the other 2 outcomes is if they say, no, we're not granting you because your claim is unfounded. But they may also say your claim is manifestly unfounded. There's a difference between the 2. Manifestly unfounded means what you are saying does not exist. It's fiction. You can't tell us there's war in that country. There's no war, we know. It has never been reported anyway. That's fiction. So it means your claim is manifestly unfounded, and you appeal to a committee called SCRA, the Standing Committee on Refugee Affairs. If, on the other hand, your finding is just unfounded, unfounded means different from manifestly unfounded. It means that which you are claiming is happening in that country, yes, but it does not affect you. You are just making use of it to escape your country and come into and go to another country. That which you are claiming is happening, it does not affect you at all. If there is war in the DRC and you come from, what's the capital? Kinshasa. You come from Kinshasa and the war is far in the east, 1,000 kilometers away. What do you mean? The same thing happened here when people rushed into the Central Methodist Church wishing to go to Canada. Their claim was that there are xenophobic attacks You can check throughout that period. There was not a single xenophobic attack in Cape Town. What they were referring to is what happened here in 2008 in Gauteng, more than 1,000 kilometers away. So that is unfounded. Now, that's how the appeal process will go. So our new law will take into consideration that people like RSDOs have to be people who understand interpretation of statutes, people who understand international law, people who can integrate between these international law and conventions. And believe you me, they are complex. I've attached as annexures in this white paper the protocol, the convention, the protocol, and the AEU convention. I've attached them there for your reference, and go and read them. You'll agree with me just how complex is that. You get headaches all the time, but because international law has to accommodate as many countries' wishes as possible. And that's why it goes round and round and round. If Christians will allow me, it's like a Bible. I can read a verse in the Bible that says you must be punished, and I can read another verse that says no, you can't be punished. And to get through that, many scholars of religion will know there have been arguments throughout centuries. So international law is more or less like that. It needs people who are very, very highly qualified. That's why we are making proposals like they were made in the UK and Canada about the level of qualification and experience of such people and their professional status in society. Thank you very much.
Thank you, Minister. Further questions? Takalani, are we okay?
I think so. We have two from Karen Duplessis from Reuters. The first one is the minister gave some example of immigration systems that South Africa is looking at as part of the reforms of its own system, such as Canada. Why Canada specifically? That is the question. And which other countries did his team look at for examples of working immigration systems? And also, there have been a lot of reports about professionals and highly skilled people waiting a long time for visas, struggling with the process or giving up in leaving South Africa completely. Are there any processes underway to streamline this, as the President has promised repeatedly in the past at investment conferences? Thanks.
Thank you.
Thank you, Karen. We chose Canada because what they are going through with people running there is exactly what South Africa is experiencing. And we thought their model will suit our needs. I give you an example. The people who were holed up in the Central Methodist Church and getting sympathy all the time from the media as being persecuted, their main aim was to go to Canada, despite the fact that the United Nations wrote them numerous letters that is not possible. They are not just choosing Canada out of the blue. It's because in Canada, there's a province called Quebec, which is French-speaking. And the people who are demanded to go there are French-speaking. But secondly, Quebec is an area where the indigenous Canadians were sent in during colonialism when the country was being taken over. And because Canada wants to be very progressive, they've put in lots of benefits in that area, in Quebec. And people know that when you arrive there, you get so many benefits that you may not even work. And that's why they are targeting Canada. That's why they are pushing and protesting that we want to be sent there. So it's not that Canada is choosing out of the blue. And when we look at what's happening in South Africa, of course we are much poorer, but comparatively speaking, we have got better benefits than elsewhere. And we know that because of those benefits, we are in perpetual problems. The issue of visas, Karen, you know, you are really tempting me, but I know journalism is like that, of course. It's experience. You answer one question, they go and repackage it and throw it back at you and keep on repackaging until you answer. I said tomorrow, I'm going to speak about this issue because there is something that has happened, which I believe is terrible, about this claim of what's happening to visas. And I will disclose it tomorrow, I promise, at 8 o'clock. I'm not campaigning for ENCA, but unfortunately, it's a platform of NCA where I'll do that tomorrow at 8 o'clock. So just be patient. But be that as it may, I can tell you, there's Vishal, who is the acting chief director of permitting, who deals with visas. There's a DG. I can tell you without any equivocation or any fear of contradiction that this story that we don't finalize scarce skill visas on time, you know, it's just being propagated again and again and again. And we keep on asking ourselves, what is this all about? There's a story that is going on that we have rejected 60% of scarce skill applications. In terms of South African law, every 4 years, you must publish a list of scarce visas. Believe you me, that list is published in a government gazette by Home Affairs. There is no way on earth that Home Affairs will ever know all the skills that are needed are in short supply in the country. It's not our mandate. But the law says we must gazette it. So what do? We ask the department which is likely to know that. That's the Department of Higher Education. And say, please develop a scarce skill list for us. The Department of Higher Education does not also do it on its own. They organize institutions like the South African HSRC, Human Science Research Council. And they go to the labor market survey, they start that work, and they put together a list, which we send to Netleg, where big business is sitting there, labor is sitting there, government is sitting there, and community. They look through it. Then we send it to the presidency. And if the president said they are satisfied, we gazette it. But because we realize that despite all those mistakes can happen, we have now adopted a new policy. We no longer wait for 4 years. If anything arises today, which you are convinced is a scarce skill, I will gazette it tomorrow. We will do that, and we've already done that twice. Otherwise, because the scarce skill was gazetted in February, we will have waited for another 4 years. February in 4 years' time, but we didn't wait. We have already gazetted twice to correct that. Now, how does it work? When you say the scarce skill visa, that company which wants to hire you, all they must do is to bring your qualifications and your profession. And it must be seen that it is on the list of scarce skills. If it is there, we've got no option but to give you a visa for scarce skills. If you are unable to provide that, what do we do? If you are unable to provide us those requirements, the documents that are wanted, what do we do? One of the requirements was that you need to have registered with the international body. If you are an engineer, it's the engineering council. We have removed it. No?
So we've removed that for ministers, for lecturers, for the professional science engineering council.
Yes. We see, I'll contradict myself. Maybe you must have one-to-one with the DG about this. But we are making some of them easier now. If you have got 100 people applying and say they all have scarce skills. And then when you check, these are, very, very junior. And we have got many people in South Africa with that. What do? Do you grant them or you reject them? And very recently we noticed that there are lots and lots of very lowly skilled people from Zimbabwe who have applied for scarce skill. So what you are being judged on is the number who applied. And they say if it's 100, you have rejected 60. That's 60% rejection. It's terrible. They don't even look who have applied. If you advertise a job for a DG, and 1 million people apply, and some of them are ordinary matriculants, what are you going to do? You're going to reject them. It's not the requirement is not there. But for those who are wanted by the economy, I can put my neck on the block. When the president had investment summit, I think it's last year, yes, there were about 20 companies which pledged for that investment. And they said for that investment, they need to bring people from outside the world with particular skills. And immediately after the conference, they gave us 3,090 applications of people with skills. We all issued them by October last year. But by January this year, the battle was raging. That no, we are not giving people scarce skills. It was raging. And I kept on saying, DG, but who are these people? Who are these people that were refusing scarce skills? Because we're not supposed to be refusing scarce skills if a person has got a qualification. And of course, the other reason is because people believe a scarce skill is an important skill. Doesn't mean that. When you say a skill is scarce, it means it's needed by the economy. But we've got few people in that area. That's what it means. For instance, when we developed these skills, there were lawyers in the country who were up in arms saying we're undermining their profession. There's no way you can undermine the legal profession. They govern the country, seeing that almost every issue is now decided in the courts by lawyers. So they are very important. But they are not a scarce skill. Because there are many lawyers within the Republic of South Africa. There are many. When I was the MEC for education in Limpopo, we had a huge shortage of maths and science teachers in Matric. Huge shortage. And I can tell you we took lots and lots of people from Zimbabwe who have got such qualifications. But now you can go to the Department of Basic Education. They will tell you that's no longer there. They established Funza Lushaka and they corrected this thing, and they've got lots and lots of maths and science teachers who are sitting at home now. And I know some people may not believe that, but that's the case. Same as medicine. I was in health, as you know, for 10 years. And we had a huge shortage of doctors. We had a program started by Fidel Castro and Tata Nelson Mandela, the Cuban program of sending students there. When it started, we sent in 60 students per annum. It then increased to 80 students per annum. But when we were preparing for NHI in 2011, we started sending 1,000 students, from 80 to 1,000 every year. You can imagine what it's going to do. Our medical school were producing only 1,200 doctors per annum when I arrived. But now they are at 2,700. And you think that must always be a scarce skill? When I became the MEC for education in Limpopo in 1994, teaching was a scarce skill, believe you me. There was a big, if you pass a teacher's diploma, you automatically got a job. You know that that's no longer the case today. It's no longer the case. So you can't have people pushing you and say, my skill is scarce. My skill is scarce. Even when it's not, and when they apply, we say no. Then it becomes a third world war, which is being waged against us. So, lastly, on this issue, the Minister of Trade, Industry and Competition, Minister Patel, has got a direct interest on the issue of scarce skill. It hits him here on the forehead. Because you are aware that he's the one who organized this investment summit for the president. And there's no way he won't be successful. So he has got a direct line to us. Any list of people that are needed in the country by any company. He gives us the list. And we won't spend more than 1 week working on it. Because otherwise we'll be sabotaging the president. We will be. But we can't do that. But some people just go on the attack. During BRICS, when we were organizing for BRICS, people complained to Minister Patel, particularly from China, that no, they are not being given visas to come into South Africa, blah, blah, blah. We asked Minister Patel to give us a list. And I said, DG, please, man, deal with this matter. And within a few hours of receiving the list, the DG came back to me and said, Minister, but these people on the list, many of them did not even apply. How do you give a visa to a person who hasn't applied? They don't apply, they go to complain before applying. I don't know whether a country must work like that. That we must all do a bushiri to each other. Yes. Because bushiri is a permanent residence of this country, the courts are still refusing us to take that status. When you got permanent residence, the people who gave him permanent residence status, who have been fired, they gave it to him when the application was still in Malawi, for your information. The application was not here. By the time he has arrived, they've already given him the skill. So should we give visas to people who have not even applied? But they do so. They do so all the time and go and make noise. And I'm saying, I'm promising, I know why this issue rose. I know. For a very big gun from a big country in the world. And they believe all the big countries, when they rear their heads, we must kneel down in front of them. That's the belief in South Africa. This whole question comes from that big man. Tomorrow I'll explain exactly what happened. Thank you very much. And before, when I do my correspondence every day, I came across this letter. It's from the president, thanking us of this progress on visas and reforms. Unfortunately, he never gave me permission to read to anybody, but because it's there, I'm asking the media to demand it from the president if he's willing to give it to you. Yes, yes. Because he is talking about this issue here, whether he's satisfied about what you are doing vis-a-vis his investment conference. You'll find it on this letter. And as I'm saying, he never gave me permission to read it. It's a letter to me. So let me respect that. If he's prepared to do it publicly, let him be the one who does so. Thank you.
Thank you very much, Minister. We check in for the last time. If we have questions, Tagalani, are we started? We started. Those of us who have requests for one-on-ones, please indicate. The minister is available, the deputy minister is available, the DG is available, the deputy commissioner of the DMA is available. Minister, just to announce, we are commencing with the public hearings this week on Friday in KZN in Durban. The details thereof will be available on the Home Affairs website tomorrow. This brings us to the closure of the media briefing. Thank you very much.
Thank you. Okay.